Welcome back to the channel. We are going to be jumping into another interesting one today. We're back on California AB5. I believe this is now our third video we've done for it on the channel. We've got some other analysis of it if you want to go check it out. We keep getting viewer questions, and quite honestly, I find it fascinating what's happening here, and I think it has important lessons for everybody, both in the trucking industry, those unfortunate individuals that are dealing with this right now in a time of great uncertainty, but also for other businesses, right? We can see how a state regulation change may cause us to shift quickly and change our business model. It also gives us kind of an idea of how we need to be flexible. As business owners, as business leaders, we need to understand that the landscape and the map that we're operating on can change. So here we have this AB5, which was adopted by the California legislature. They've left a lot of questions, and so we're going to be jumping into what some of those questions are, try to at least give some thoughts on what some of the answers might be, and really give you some ideas of things that might be considered, and then also hint on some planning strategies for those that you might be out there, what are things you might want to start considering in the future. And for those of you that aren't necessarily in the trucking industry, but are just a business owner, these are things you can start thinking about, right? Like, let's see what happened to these truck drivers, many of them business owners, small business owners. What happened to them? And how could this impact me and my business in the future? And what type of flexibility and planning should I put in place, right? So I think this is instructive for all of us. Guys, my standard disclaimer is we don't do legal advice on the show. Particularly important today, I'm going to give you a lot of opinions and ideas. We got a lot of uncertainty here, right? So we don't know what's going to happen. A lot of this is going to be fact-specific about you, your situation. So we'll give you some things to talk about. We'll give you some ideas. We'll give you some education. But you're really going to have to sit down and talk to somebody who really knows your situation, your facts, and all the details, and can really work through it. Also not financial or investment advice. But let's jump into it, give you some ideas of things to consider. Obviously, there's a lot of open questions with AB5. In many ways, it seems like California legislature jumped into this without thinking. For those of you that aren't familiar, California AB5 makes it essentially very hard for somebody to be an independent contractor unless there's a specific exemption for a specific industry. So almost everybody doing work for somebody else now probably has to be an employee, not an independent contractor. That caused a lot of situations, right? So a lot of people get caught up in this, and the trucking industry is particularly under attack because of the nature of the business is a lot of people own their truck, they drive, they do a lot of contracts independently, right? So they are independent contractors under the way most other states would view it. But California is now saying, well, we don't want independent contracts, got to be an employee. And of course, if you've seen the recent U.S. Supreme Court decision to deny cert on a California appeal, has now basically said, for the time being, that this AB5 can be enforced upon the trucking industry. It's left a lot of open questions, and we're going to jump right now to a letter from, this is on a website called Landline, and Landline has asked a number of questions about these laws. And so here's the questions that came, and they're recopying questions from the Owner Operator Independent Drivers Association, right? And so will AB5 have any impact on owner operators with their operating authority, right? So this is talking about employers and employees. And so now this is an open question, and I agree. This is a question. I'll give you some thoughts on some of these questions as we go through. Some of these questions are just open. We don't know. So will owner-operators with their own operating authority be caught up in this? Certainly not your traditional employer-employee relationship when you are both the employer and the employee there, but you may have to jump through a technical hoop of having a company and then having yourself as the employee of your own company, which is a lot of paperwork and really doesn't address these kind of public policy concerns California is trying to get to, right? They were trying to make sure that people weren't being abused by their employers, improperly classified as independent contractors, really going after, like the Uber drivers and people like that, trying to get them some employment rights. These weren't really in the same class of situation as maybe a truck driver owns its own truck. Will AB5 prohibit traditional lease agreements between owner-operators and motor carriers? Does the state believe owner-operators leased to a carrier would be able to satisfy the business-to-business provision? So they go back to the Bordello standard, right? Bordello standard is your more traditional independent contractor classification standard. Is that considered business-to-business? Is the owner-operator doing business with the trucking company? Is that going to meet that standard? Good questions, right? And so, it would seem from a technical standpoint to me, if you actually have a business and your business is doing business with another business, you've now technically become a business-to-business relationship. The problem you're still going to have is internally, what do you do now? Now your business, your company that owns your truck and presumably you work for, if you're this trucker, has to then in turn hire you as an employee, right? If we work through the way this works, is you can't be an independent contractor. Maybe not that big of a deal, but certainly you're going to have to do a lot of withholdings and compliance and pay certain unemployment taxes and other things, right? So it's going to increase the expenses if we do try to set up this business-to-business relationship. Will AB5 apply to owner-operators who are residents of California but leased to a motor carrier domiciled in another state? This becomes where we start to see some of the interstate commerce issues come in, and we're going to dive a little deeper on that here over the next portion of this video. But if you have somebody who's a resident of California, certainly if they're working in California, that's where California would have the strongest case that they can regulate the workers' environment. We certainly have a lot of these cases outside of trucking, right? So we have people who are, say work for a restaurant, and the restaurant might be headquartered outside of California, but, they have a location in San Francisco. Under all analysis there, and up to today, people would say you would be subject to California employment law for that. We're even seeing that now with a lot of the work-from-home employees. Employer maybe anywhere in the U.S. or maybe even international, they've got employees sitting in different states. Basically, it's working out that those employees have to be regulated by the state where they're actually working. And so all the employment relationship, the time off, the paid sick leave, all the other things that might come up are being governed by where the employee is under most analysis. That seems to be the way things are working out with the guidance. So if we have an owner-operator who is a resident of California, to the extent that they're an employee of their own company, since they're the owner, right? Their company would be the owner of let's say, of the truck. They, as the operator, and since they're a California resident and presumably doing significant work in California, they would then be subject to this California law. So that one there, I think we kind of have some shading of where that might come. How about an AB5 to an owner-operator that's resident of another state who is leased to a carrier domiciled in California? Again, now, so we have an employer potentially in California, but the owner-operator is a resident of another state. Now, importantly, and I think another question that comes in here that gets layered in is where is the the trucking, right? So presumably the owner-operator is going to have an entity set up at some point here to try to do that business-to-business exemption, which was referenced earlier. Where is that entity at? Presumably, let's assume it's a non-California entity. Now the question becomes, can you just have a company lease a non-California entity and use that? That's pretty tricky. I've seen that as a idea. I think what's going to happen is they're going to examine that relationship. I think when you see the guidance come out, they're going to look at whether that out-of-state leasing really is California or not, right? So just because everybody, let's say you have a driver in Nevada and you have a holding company in Nevada and you keep coming into California, if you're constantly in California, I bet California is going to say sufficient nexus. That's a word you hear by the states for their connection to a matter. They're going to say this is all connected to California. We don't care where these people live. They are got a sufficient connection with California. You would see this in other cases too, right? If you had, let's say you lived in Nevada and you crossed the border to California to work, right? You would certainly fall under California employment law for the time you're spending at your employer in California. I think they're going to make that same argument here. What's different with trucking is as we're crossing state lines, and we're going to jump into this here in a few minutes, the Commerce Clause kicks in, and potentially what we call the Dormant Commerce Clause. I'll break those down for you in a minute. But those jump in and may change this analysis. But we're going to have to look at the nature of this analysis. I expect when we see the cases and the guidance come out, the connection with that out-of-state entity and how frequently that entity is interacting with California is going to be important in that analysis. Will AB5 apply to drivers that only pass through California but do not begin or end a trip there? I think that is perhaps your best case, right? The geography of California is such that, generally you're going to be beginning or ending a trip in California. But there certainly are routes where, say, you're taking something from Arizona to Washington State or other situations where you're just passing through California, right? Because it's so far because it's a coastal state, you're going to have more beginning and ending trips there than you are going to have pass-through trips. Passing through, I think, based on some of these U.S. Supreme Court cases, California is going to have a hard time just saying that driver passing through California gets governed by California employment law. And we'll talk about that some more in a minute. And now we're talking about a multi-truck situation. The owner-operator might hire their own employees to operate their other truck and pay applicable payroll taxes. They have a lease with the truck owner, but the owner-operator supplies their own employees to drive the truck. Will AB5. AB5 doesn't talk about how the assets get to the business. It just talks about the classification of the people working. So I don't see an issue with AB5 with respect to how you structure your business, right? So you could potentially have, a lease arrangement for a truck and then have an employment arrangement for an employee that is working for you. So I think you're going to have to look at that. Now, one of the complexities I think we're seeing is that these lease arrangements and the employment or independent contractor relationships are being challenged with AB5 and maybe being consolidated and viewed as one. So still an open issue, but I think certainly for a second truck, it's a stretch to say that AB5 is going to pick up that. Does California have a website or phone number available for the answers? I mean, I'll tell you the truth, California probably just doesn't have the answers to these questions, right? They are still figuring this out. There's been a lot of litigation. Obviously, it's fairly recent now since the Supreme Court denied cert. There's going to be more litigation on this and the things we're about to talk about. Honestly, California doesn't have the answer, and they probably don't want to lock themselves down to answers, which really is unfortunate for the business owners that are dealing with this, right? Because if you're that truck driver, that owner-operator working with California, I mean, you don't have answers. Let's see here. And so we're just going to take a quick glance at AB5, right? AB5 is talking about worker status, right? Let's go back to the source here. And so basically, you've got to meet these conditions in order to have an independent contractor. It has to be free of control and direction from the hiring entity and performance of the work. Has to perform the work that is outside the usual course of the business, and has to be customarily engaged in independent trade, occupation, or business of the same nature that involved in work performed. This is where some of these questions about can you have a company set up, with the owner-operator owning the company, and then have, have somebody else hire that company, right? So the entity that wants the freight moved hires the company, and then the company deals with its driver. I don't see anything here that really prohibits that right now. We may get some state regs that challenge that, but it's looking at the person who is hiring the person, right? So there we go. So that seems to indicate that this is not regulating the relationship between the two businesses. It is regulating the relationship between the business and the person working for it. And so if we apply this kind of analysis here of AB5, and we look at the relationship between, let's say, a hiring entity and an entity that's owned by an owner-operator, I think you would do well on this test right here. Right, the owner-operator would be free of the control and direction from the hiring entity, right? Because you're just going to be told what to pick up, what to drop off. You're not really going to be told how to do it, etc. Have to be outside the usual course of the hiring entity's business. That's interesting, right? So what is the business of the person hiring you? Is this a freight company that just does freight? In which case, maybe we have a problem with test B here. Or is it a company who maybe has multiple operations and freight is just part of it? So there we may have an interesting interpretation question on B. And is the person customarily engaged in independent established trade, occupation, or business, same nature? So if you set up a company that does trucking, owner-operator style, certainly C doesn't appear to be an issue on its face. So here we are, right? So I think we have a lot of open questions here, but it appears that type of structure may work. Although again, it's interpretation because this wording is so broad. They tried to make everybody an employee, but I don't understand how it would work if the company who wants to hire somebody to move the freight hires a company, and then that company hires the truck driver. And again, now the owner-operator is the employee of their own company that they own. California wouldn't seem to be able to require the person to be an employee of two companies rather than one, right? So from a logical standpoint, I think California is reaching their goal by getting get the truck driver to be an employee somewhere. So let's zoom out a little bit here. Let's talk about some broader issues here. About how this may play out from really the interstate commerce analysis, which is what's going to be so important in the coming litigation. And I can almost guarantee you there will be significant litigation over this. There's going to be a lot of people caught up in the middle. People are going to be turned into test cases. There will be fines and penalties and all these other fun things coming until we get to an answer. States generally have the internal ability to regulate their affairs, right? So California gets to say generally what happens in California, just like Nevada gets to say what happens in Nevada, and Florida gets to say what happens in Florida. So that part is well established. Most employees, are in a state and they stay in that state, right? So most employees show up to a workplace or stay at their home in a certain state. It's pretty clear to establish where the employee is. There are some employees that, by the nature of their work, do have to cross state lines regularly, right? This is truck drivers, airline pilots, flight attendants, etc. But generally, the state gets to regulate what's happening within its state. And to some extent, in the trucking industry, there's some well-established precedent, right? A truck will get inspected in different states. It will certainly be subject to speed limit and other safety considerations in certain states. May have tax considerations as it's flowing through different states, right? So that part is well established. Weight limits, weight inspections, etc. That part is established. But the interstate commerce part of this becomes more complex, and we have several U.S. Supreme Court cases dealing with interstate commerce, both in trucking, trains, interstate travel. And they've largely rested on what they call the Dormant Commerce Clause. So the U.S. Constitution has the Commerce Clause saying that Congress can regulate commerce between the states, Article 1, Section 8. In fact, it is one of the most powerful, if you want to use that term, constitutional provisions. Go Article 1, Section 8, Clause 3 says that Congress can regulate interstate commerce. And as we've grown into a modern economy where the U.S. has a lot of interstate commerce, a lot of stuff falls underneath the Commerce Clause. So it's become a very important clause as the federal government has grown in size and scope. And so as a corollary to that, the courts have come up with what they call the Dormant Commerce Clause, which essentially says states can't do things that prohibit interstate commerce. And so There's a mud flap case out there. I believe it was Illinois. Illinois basically wanted people to use different mud flaps than the neighboring states, which, as you can imagine, for truckers would be quite a pain if you had to change your mud flaps at the state line as you flowed through different states. U.S. Supreme Court said that violated the Dormant Commerce Clause. 1981 case with Iowa and truck lengths basically said Iowa couldn't have a different truck length standard than its neighboring states because, again, it broke up interstate commerce. You couldn't just set up a truck in one state, truck it through Iowa, and keep moving because you may have length requirements in Iowa, right? Again, a state prohibition on interstate commerce. So how does this apply? I think if we use that Supreme Court decision with the Iowa truck length case, and we fast forward it over to California now, it would seem that California certainly couldn't regulate trucks with respect to the employer-employee relationships through California. Because if you've got something set up in Arizona, you got something set up in Washington, set up in Oregon, whatever, and you just happen to be clipping through California, it would be a massive pain to then have to switch everybody to being an employee at the California line, switch them back to being an independent contractor as they leave California. Looks very similar to that truck length case. I think also you can extend that to talk about trucks dropping off and picking up in California, right? So certainly for drop-offs, if you've got a truck started in another state destined for California, if you suddenly wouldn't allow them to cross into California or stop them, that would break up a lot of interstate commerce. There are some websites out there saying, one answer to this is to go drive into California, drop off a load, leave California, pick up another load, bring it into California. Again, now there's a Commerce Clause issue too, in that owner operators that can operate from, say, Texas to California, but then have to go back to Texas to get another load to come back to California, are at a competitive disadvantage to those owner operators that can go into California, pick up another load, take it back to their home state, and then flip around and go the other direction, right? So there are a host of interstate commerce issues here, and the Dormant Commerce Clause seems to indicate that there will be significant limitations on what California can do, particularly with respect to people who are not directly tied to California. So if you're not a California resident, your truck is not registered in California, your company is a non-California entity, probably we're going to see some relief for those in some sort. It's just a question of how much relief is going to come under a Commerce Clause. Litigation's coming, folks. Keep your eyes on it. If you are in this situation, I'd be talking to an attorney and looking at what your options are. You may want to be looking at potentially breaking your connections with California, leaving, if that's an option for you. I know many people have family, have relationships in California, maybe have children in California. It becomes hard to just pack up and leave. A lot of people have been leaving California. If you're in a situation where you can say, hey, I'm going to move across the state line and get away from this, and then you can establish an entity in a non-California state, you may find you get a lot of relief. It may be too early to do that, but you might want to start preparing in case the court cases come in your direction, right? Talk to your counsel about what you want to do, your preferences, but, I would imagine there may be some people in California who want to start boxing their houses up and hoping that the cases come out there in their favor so that they can just take the things across the state line and, set up a residency in a new state and work better that way. You may want to look at moving your entity out of California. You may be in a situation perhaps you have a California entity, but you're not in California. Maybe you left California, but your entity's still in California. There's a lot of things you need to look at here, but the litigation's coming. I would say as a business owner operator, if I was in that situation, I would be looking at what my options are as far as breaking connections with California legally, not just changing paperwork, but actually doing the work to fully break my connection with California so that I'm not regulated by them here. These are, obviously tough regulations and may cause unnecessary expenses. So look at that legal option of fully breaking those connections with California, starting over or moving your business somewhere else. But I've been watching the litigation. I think we will get clarification on this eventually. There are too many trucks coming in and out of California that they're not going to be able to ignore this forever. Plus, we'll just start seeing administrative action, right? Eventually, as the dust settles, the state of California will start, potentially doing some crackdowns. They'll figure out where they want to apply their enforcement authority and attempt to invalidate things or fine people or whatever. California will start jumping into it. So the litigation is coming. So just be prepared, be watching right now. That's what my best advice, but also start thinking about, changing your connections, changing your relationships, and what you can do. I don't think, and I've seen this advice out there, if you're in California resident, and now, somebody's saying, hey, set up a company in another state and then have that company get contracts in California. My guess is California is going to figure that out. The fact that you're in California, the fact that you're spending significant time in California, the fact that your primary work location will probably be California because that's where you live and that's where you go for home base and set up contracts, etc. I think California will try to push those folks into being regulated by California. But, on the other hand, somebody who has a company in Nevada, lives in Nevada, and then just occasionally does business with California and maybe does business with other states too, may be harder for California to get a hold of them under this law. The other thing we need to watch too is other states may copy this law. So we'll probably see this whack-a-mole situation. But ultimately, at some point, and it may be years down the line, as this develops and twists, the U.S. Supreme Court will probably have to address it again. So even though they denied the one case, I see trucking as being such a significant industry and so much money flowing through it, and the fact that more states may follow California. These issues will be dealt with eventually, but in the meantime, we've got to carry on our businesses and our lives, and so that means we need to figure out solutions. I hope that's helpful. Do join me in the comments. I would love to hear from you. A lot of this content is being developed because people are asking specific questions. People are asking about what happens. I find it fascinating. I think it's helpful for everybody to understand how state regulations play together. This is a hot issue, and hopefully a lot of you can push through this, right? It is a tough time for business, tough time for life. I bet some of you are in tough situations that are dealing directly with this. Other businesses will be in tough situations as states continue to change their regulations or are not really sensitive to the needs of the business owners or the individuals in their states. So hang in there. Keep looking for options. Do look forward to reading your comments about what's going on in your world. If you're interested in being a business owner, business leader, and talking about legal issues and is relevant to it, please subscribe to the channel, ring the bell for notifications, tell your friends to come hang out here, share this video, and of course, give me a like. So, all right, folks, looking forward to reading your comments. Talk to you soon.